Minister Edwin Tong.
Madam, I thank Mr. Ng for speaking and expressing support of the bill. I just want to go into one clarification before I answer Mr. Ng's three questions. Mr. Ng cited Asia Development and raised some good points regarding the delegation of the ministerial functions under the new Section 36 of the Interpretation Act. Would just like to point out for this House that Asia Development deals with the devolution of ministerial functions under the Kaltona Principle. The principle is explained in the explanatory notes of this bill. It's a common law principle established by the English Court of Appeal case. In that case, the Court of Appeal recognized that the minister's duties and powers are normally exercised by responsible ministers who act under the authority of the minister. It is also recognized that the decision of the official is the decision of the minister in this instance. The new Section 36(8) of the Interpretation Act makes clear that the principle of the Kaltona devolution, which has been applied by the Singapore Court of Appeal in Asia Development, remains unaffected. On the other hand, what is being introduced in this bill is a delegation of ministerial functions. Conceptually, delegation is quite different from a devolution. Where a power has been delegated under the Interpretation Act, which is what this bill seeks to do, the delegate exercises the power in his or her own name, as I've explained in my speech earlier. In contrast, where a power is devolved under the Kaltona Principle, then the authorized officer expresses the power in the name of the minister. So I just want to clarify that before I address Mr. Ng's three questions. Both delegation and devolution, though, are important tools to allow the Singapore government to respond quickly and effectively to the needs of Singaporeans, and there are also clear lines of accountability to Parliament and to the public. Mr. Ng asked how one might discern the contrary intention as appears in the Act. And I think the question is how then, or what are the factors we look at to discern this contrary intention? Mr. Ng would know that this is actually a matter of statutory interpretation, and it's not uncommon for pieces of legislation to contain this phrase unless the contrary intention appears. In fact, this phrase appears more than 70 times on our statute books and can be found in acts such as the Partnership Act, the Medical Registration Act, Copyright Act, and Companies Act. In the Interpretation Act alone, the phrase appears more than 20 times. So this is a concept that courts are familiar with, legislative users are familiar with, how to interpret them. On a more specific question as to how this contrary intention against delegation can be inferred, there are well-established principles that can be applied. The express language of the legislation should first be looked at. That is the best indication of what the intention of the draftsman is in that piece of legislation. The intention can also be implied by statutory context in looking at the overall architecture and context, construction of the provisions, and the location in which this particular provision sits in the context of the broader provisions in the Act. Mr. Ng also asked what other relevant factors could be taken into account. These include the nature and gravity of a function, and I think Mr. Ng himself mentioned nature, purpose, and scope. They are not different, as well as considerations of administrative necessity. The exercise is similar to deciding whether the common law doctrine of Kaltona devolution, which I mentioned earlier, applies. So to illustrate, at one end of the spectrum, where power affects life and liberty and is quasi-judicial in nature, such as a hearing of an appeal, then unless the express language makes it clear, then it is likely that there is an intention against delegation. On the other end of the spectrum, where the function is administrative in nature and likely to involve a substantial volume, such as transmitting a document from one authority to another, then it is very unlikely that there would be an intention against delegation. Mr. Ng also asked whether statutes can expressly address the question of delegation. Short answer is yes, and I think to the extent possible, this will be made clear in provisions, and that's part of the exercise that the AGC is undertaking. Specific provisions in an Act of Parliament may allow the delegation of functions, for instance, by providing that a minister may authorize another person to exercise certain functions that are conferred on the minister by the Act. The new delegation framework in this bill does not affect those statutory provisions. Mr. Ng's second question is how a public body's opinion, belief, or state of mind should be determined. Madam, in general, a public body has, of course, its own independent legal status. But at the same time, it is also made up of natural persons. And the natural persons will usually comprise a chairperson or some other members within the body. And it is not uncommon for the chief executive to also sit as a member of the public body. The opinion of the public body would therefore be the opinion of the constituent persons. And this opinion will be formed in the same manner as how a public body ordinarily makes a decision. So, for example, if a statutory board can make a decision by a simple majority of its members, then this simple majority can likewise form an opinion for the purposes of making that particular decision. The exact process would, of course, depend on the legislation that constitutes the public body and any rules that may apply to the process under which the public body undertakes that decision-making. The broader point here, though, is that there are established legal doctrines which can be used to determine the state of mind of a public body, and this bill does not seek to introduce anything which is fundamentally new or controverts existing principles in this regard. Mr. Ng's third question relates to good practices recommended by the Court of Appeal in Asia Development. Madam, shortly after the decision in Asia Development was released, administrative guidance was issued by AGC to public agencies. The administrative guidance effectively adopts the good practices that were recommended by the Court of Appeal in Asia Development. Madam, this brings me to the end of the three responses that I had from Mr. Ng, and I think I've touched on all the questions that he's raised. With that, Madam, I beg to move.
The question is that the bill be now read a second time. As many as are of that opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Statute Law Reform Bill.
Committee stage, what day?
Now, Madam, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 26 stand part of the bill. As many as are of the opinion say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Second Minister for Law.
Madam Deputy Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, Madam, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as of that opinion say aye.
Aye.
To the contrary, say no. I think the ayes have it. The ayes have it.
Statute Law Reform Bill.